Good morning, everyone. Welcome back to the Real Estate Group's live video extravaganza. I'm Zeno Lancaster I'm the owner of Lancaster Law Firm. I promised myself I'm not going to swivel so much today. So watch me sit real still and be amazed. So I'm here to talk to you about real estate law, real estate strategy. We are headquartered in Asheville, North Carolina, with offices in Hendersonville and Canton, North Carolina. We only do real estate, so if you guys need a new option or an option at real estate law, we are your go-to for start to finish and full service real estate. So reach out to us. You can find us online, Google us, Lancaster Law Firm. My email is Zeno, Z-E-N-O, at lancasterlawfirm.com. We've got 3 attorneys other than myself on staff. A large paralegal staff of, I think, 3 or 4 pre-closing, 1 post-closing, 1 seller side only. We've got lots of staff to help you out. We've got we search title in-house. I'm going to talk a little bit more about that today and the advantages you can find there. But I'm also going to talk about some title questions I see realtors have. So stay tuned if you want to get some information on that. So what I'm going to dive in first is what a title search encompasses. What's the scope? So when an attorney title searches, what are we doing? So we are title searching to make sure that your seller actually owns the property. You'd be surprised. We're making sure they own it by themselves, or they've included with you the other people that do, that there are no liens on the property that we need to pay off or get rid of or have canceled. And other things. That's a whole show. Frankly, it's a multi-hour class I could teach, and that would just be the intro. But that's the long and short of it. One question I get a lot, and of course we do all of that so the buyers don't take ownership of the property subject to all those potential problems. Okay. Realtors don't certify that. Sellers don't certify that. A lot of times they don't know, especially if they inherited the property or some such. A lot of times they've done it incorrectly. If there's been a divorce amongst the sellers, we see divorce attorneys give them great advice on the divorce proceedings and poor advice sometimes on the real estate side of things. A separation agreement doesn't convey property, for example. So if you say Bob's going to get the house in the separation agreement or the divorce agreement, whatever, the settlement, you still have to do a deed. A lot of times they forget that very crucial part, and years go by and then Bob's in Bermuda with his new wife, and it is very difficult to get him to sign a deed at that point. So just an example of things, the reasons we do title searching. So what does a title search encompass? So marketable title in North Carolina, and I've got the statute pulled up. It's under the Real Property Marketable Title Act. You can Google that and read all through it. The marketable title in North Carolina is described as 30 years. So if you've owned that property for 30 years, all other interests that aren't subsequent in our own record are extinguished. Now there are 13 exceptions, and that's why you hire a lawyer. That's why you're not going to be able to read this act and teach yourself to title search and close on closings without a lawyer involved, because there are 13 exceptions to this, and I can tell you there are probably more. I sure don't see IRS liens on here, and that would be a big exception. But if you own a property, anything, and you've owned it for 30 years, it extinguishes all prior interest and all that. So if Bob owned the property, he deeded it to you in a questionable deed, and 30 years pass by, you're probably good to go. Marketably titled. Marketable means you can sell it without problems. It's marketable. So an attorney has to get in there and certify that to the next buyer, because the buyer is under contract to purchase marketable title from your seller. Now, sometimes, as you've probably seen on closings, we can't get there. There's a problem, and we have to decide, do we want to go back and cure this and make it marketable, or do we want to pursue options where it's insurable, et cetera, et cetera, et cetera. And again, that's something the attorney can discuss the risks of with the buyer and see if we're good to proceed that way. Okay. So 30 years is what we're looking at. So what that means is In a lot of cases, the attorney is searching title for 30 years or more. Sometimes grandpa got the deed 100 years ago, and then grandpa passed the property to his nephew in his will. Well, that means that in the past 100 years, there's not been any other deeds. Grandpa got the property, and then we have to go pull an estate file and confirm that the nephew obtained the property by operation of law. That means we did a 100-year search. We don't let anybody know that typically. I mean, at least I don't. I don't reach out and say, hey guys, I just wanted to let you all know this was 3 times as hard as it had to have been. We don't get to charge. We rarely get to charge more for that unless there's a real good reason to do it. And just throwing that out there to let you know. So if you hear about how far, what the searches encompass, it's usually 30 years. Now you'll see in every one of my engagement emails, if you've worked with me, you've seen this, whether you've read it or not. It says in part of it, now this is the buyer because we only search title to the buyer for the buyer. So if it's a seller side, you wouldn't see this. We will obtain for you a separate service provider for your title insurance. Most people don't care which provider we provide on title insurance. And the reason being is that we can, in an effort to help find the lowest cost on title insurance premiums, we often attempt to tack on to prior policies whenever possible. That means if the prior owner or a prior owner, two or three prior owners ago, obtained a title insurance policy, we can tack on to that, which means that we can start with the date of that policy, search forward, and it can save the buyer hundreds on their title insurance premiums. It also ensures the 30-year search. It ensures title for that 30-plus year search that we need. So that when that happens, sometimes we'll still go back and search the full 30. If there's questionable items on the title insurance policy, if there are questionable items on title, but oftentimes we start with that policy and search forward because it's already, there's a title insurance company, a huge underwriter with millions and millions and millions of dollars is saying, hey, this title's good, you're good to go. And in our opinion, our buyer is completely covered in that way. It's based on another attorney's title search already up to that point. And unless we think that maybe that attorney's not that great at title searching, maybe they've been retired or worse, disbarred or something, if we see something like that, perhaps we take it back. But otherwise, if it's a well-known local real estate attorney, we can be pretty confident that the title search can be pretty decent, okay? And then we start there. So if it's from 2010, we get a prior policy from 2010. Oftentimes we'll search from 2010 forward. We get the benefit of that prior search that we tack onto. That's not always possible. There's not always prior policies out there. But the two benefits are that it ensures any previous problems, so those go away immediately. It can solve a lot of those issues. And also it saves the buyer money on their reissue rate. And you'll see in the offer to purchase contract, the sellers are actually obligated to send that over, the prior policy. I know that that's not a big thing with any of the realtors or clients, but sometimes we'll ask them for it and we'll kind of mention, especially if there's pushback, and no, I'm not doing that. I've got better things to do today. Well, it's actually in your contract that you'll use your best efforts to send over any copies of prior policies. So look that up. Let's see. And we do offer in our engagement emails, if you don't want us to tack onto a prior policy for some reason, let us know and we won't. Now, I've never had a client say, don't tack on, don't save me hundreds in title insurance premiums, don't do it. That's a terrible idea. I've never had that happen. But we do give the clients an option. If they don't want us to tack on for some reason and they want us to go get a full search, whatever that means, and sometimes they get a full search anyway because there's no policy to tack on to, right? But if they for sure want us to and they don't want us to consider any prior policies, they certainly have the right to tell us to do that, and we will honor that, okay? Most attorneys do it this way. It was certainly how I was taught to do it this way. I'm certain, and one thing I'm certain on amongst attorneys who differ in opinion is that they differ in opinion. Some attorneys probably don't do it this way, but I can tell you that my firm does it this way, and most real estate firms, as far as I can tell, do it this way. I know that some of the bigger ones here in the area do it this way. So I am in good company there. Please post any comments or questions about all of that below, and we'll hash it out. If you're hearing from, I just want to throw this out there because what prompted this topic was, Zeno, another attorney told me you only search title for a certain amount of years. Well, number one, that other attorney is my competitor, so keep that in mind. Consider the source, guys, please. Consider the source. But also, I can just tell you that most attorneys do it this way that I can tell. I get asked for prior policies all the time from other attorneys who want to use them and tack onto them. Big attorneys, popular attorneys in the area. You know, I would consider the source there, and hopefully they're competing on things other than disparaging my title searching abilities. But anyway, so keep that in mind if you're hearing that. If you hear something like that and you have questions, hey Zeno, tell me about your title searching. I had this concern. Happy to hash that out, guys. I'm not going to be offended. We've never had a title insurance claim, knock on wood. I think our reputation amongst the title insurance companies for that reason is very good. We are not cut off from any or disapproved from any of the title insurance companies because our title work is pretty darn accurate. Okay. What else? I want to talk about estates. Another realtor had asked me to talk about this. So you get a property that's gone through. I inherited property from grandpa. I want to sell it. Well, the first question you should ask that person is, has grandpa's estate been administered? Not only has it been administered, that means they've gone down to the clerk's office in the courthouse, filed the, you know, if there's a will, administered the will, hire an estate attorney, get them to do this for you. It's not easy. If grandpa died without a will, the clerk might walk you through it. I'm still hiring an attorney. First of all, I'm an attorney, so I'm going to recommend you hire an attorney. But go down to, you're going to have to file that with the clerk's office. And if they died somewhere other than the county that the property lies that we're trying to sell, their documents have to be filed in that county too. So if they died last year in Florida and you're wanting to sell property up here in Transylvania County, they have to pull copies, and it's called an ancillary estate, and file it here in Transylvania County from the Florida estate before we can sell the property, before the buyer's attorney is going to be able to certify. Okay, that has to happen first. So just because they're written in they have a copy of the will and they say, right here's where grandpa gave me that property, that doesn't do anything until it's filed and administered at the courthouse. Frankly, one of the things they do is make sure that will's not fraudulent. They make sure it's executed properly. It's not been changed and amended. It gives other heirs the ability to, frankly, to refute it. It gives creditors the ability to file claims against that person's estate. All of this has to happen before they can convey the property. Okay, so that's the first question you ask someone who says they've inherited property. How inherited have you? You know, have you filed the estate down at the clerk's office? Has it been administered? If the answer is no or I don't know, stop and find out and get that going if it hasn't been. I'm happy to help with that if it were to come up case by case, and we'll get that thing administered. Okay. What else? I think that's all for today, guys. Put any title questions you have in the comments and questions below, or questions on estates and how they're administered, and when they're ready to sell. And we'll go from there, guys. Again, I'm Zeno Lancaster. We'd love to work with you. If you know anyone who would benefit from this group, please invite them in. Have them follow us on Facebook. We have a Lancaster Law Firm page, my personal page, flying_casual on Instagram, Lancaster Law Firm on Instagram. Follow us, invite. It's really nice to have other people's perspectives and wisdoms in this group. And I love to hear it. I love to see the back and forths as we all become a little smarter in real estate. Have a great rest of the week. Call me if I can help.